Hello, and thanks for joining me on Navigating the Estate Plan with Caress Law. I'm Tammi Caress, and today we are going to talk about probate and how to avoid it. And now time for the dreaded disclaimer. The information provided in this podcast and associated material is intended to furnish listeners and users with general information on matters that they may find to be of interest. The information in this podcast provided by Caress Law and its agents are for general guidance and is not intended to replace or serve as a substitute for any advisory, tax, estate planning, or other professional or legal advice, consultation, or service. Sometimes we may reference third-party materials or websites. Such links or references are only for convenience of the listener, user, or browser. Caress Law and its agents do not recommend or endorse the content of third-party information or sites. You should consult with Caress Law professionals or other professional advisors for advice concerning specific tax, estate planning, or other matters before making any decision. Whew. Okay, let's get started. What's probate? Probate's one of those things that people know are bad, or they hear it's bad, but they don't really understand what it is. Essentially, it is the process of administering your estate at death, and it's a court-supervised process. So you're going through the courts at death, or your executor or personal representative, as we like to call them in Oregon and Washington, will have to file some paperwork with the court at death in order to administer your estate and ultimately get the assets out to the beneficiaries. So it is a legal process to settle your estate. Now, let's talk about what is subject to that legal probate process. And we call those probate assets. And it's essentially just about anything that you own. It's a bank account, real estate, stocks and bonds. If you have any company or business assets, it's even vehicles, and then even your household kind of tangible possessions. Those are all potentially probate assets. Now, I have lots of workshops on what is a probate asset and what makes it a probate asset versus a non-probate asset. And it's all about how the assets are titled. We're not going to go too much into that today, but the one important thing to know is that if you die and you have assets that are in your name, solely in your name with no beneficiary designation, that is a probate asset. We will get more into that a little bit later on. Okay, so how do we determine if someone needs to go through probate? What vehicle do we use to go through probate? And the answer is a will, typically. Many people, this is a very common misconception, many people think that a will avoids the probate process, and that is untrue. Actually, that is the document that is used to determine who receives your assets that are going through probate at death. So a will does not avoid probate. Now, what happens if you die without a will? Which, by the way, I think it's between 60 and 70% of people die without a will. So lots of us out there. That's called intestacy. And essentially, Oregon and Washington and other states, depending on what state the deceased lived in prior to their death, they have state statutes that dictate or determine who will inherit the deceased assets at death. So an intestacy, that's what that means. Someone died without a will. Now we're going through probate to disperse those assets to those heirs that would inherit under law, not under a will. The process is actually the same for both. There might be a few extra steps if you die without a will, but the process is essentially the same. And let's talk about that, the steps to probate. So essentially, in order to get a probate started, someone has died and another person has to petition the court to administer and probate the estate. Who is that person? That is the executor that you have appointed under your will, or the deceased has appointed under their will is the person who generally or typically petitions the court to ask the court permission to first probate the estate and second, appoint them as the person who is in charge of doing that. So many people think that when you have a will, because you have named someone under that will to administer or settle the estate for you, they automatically have that power. They don't. They don't have that power until the court actually gives them the power. So simply putting it in the will, naming someone, it's good in the sense that you are controlling who that person is, who you want to be in charge of this process, the estate settlement. But that person can't do anything until the court gives them special papers to allow them to move forward with settling the estate. I get a call oftentimes in the office that they call us and say, hey, I went to a bank. I'm the executor under the will, and the bank isn't allowing me to gain access to this account. Well, that's because they haven't been appointed. They don't have court-appointed paperwork that's giving them that authority. So a will simply is a nomination of a person. It's not the appointment. The court is the only authority to make that appointment. And so the court will issue what we call letters. And they're letters of testamentary or letters of administration. So if there is a will and the nominated executor or personal representative under the will petitions the court to probate the estate, that person will receive letters of testamentary from the court. And that's their power. That's their power to do anything that they need to do to settle the estate. Now, what happens, or who is that person if someone dies, the deceased dies, and they don't have a will? Good question. Essentially, a lot of times it's a family member or a relative. It could even be a creditor of the estate. There are statutes in place that say who the hierarchy of people that can be appointed. And, typically it's a spouse. If there is a spouse, if there's no spouse, it typically can be an adult child. I will say if you die without a will and it's an adult child and you have other children, there's going to have to be some sort of consent as to who can be appointed, or if there's not, there's going to be notice to everyone and potentially a hearing on who gets appointed. So that's what I mean by if you have a will, the person nominated in the will is priority appointment. There's not this notice to get them appointed or hearing. If you don't have a will, it kind of falls under whoever is a priority appointment under state law, and whoever steps into that role and petitions the court. If there's anyone else out there that has a higher priority of appointment, then we need to get that person's consent. Otherwise, we're waiting, 20 days before you can get appointed, and it just causes further delay. The other thing to note is when in Oregon, especially when you don't have a will and someone is petitioning the court to probate it, they typically are required to get a bond. And essentially, it's insurance equal to, usually a little bit more than, the value of the estate. And so that person has to get bonded so that if they take all the assets and run, the beneficiaries it's like insurance so that they can get paid. Now, that doesn't allow that person to take the money and run. I mean, that's not a good thing. They are required to pay it back in that scenario, but that's another step that can be avoided if you have a will. If you have a will, we can say in there that we're waiving bond for the person that you've nominated. So another good reason to have a will as opposed to no will at all. The next step in the probate is we actually give notice to the beneficiaries and the heirs. People ask, what's the difference? Good question. A beneficiary or a devisee, if you want a legal term, is a person that you've actually named in your will to inherit from you. Heirs are people that would inherit from you if you died without a will. So if you die without a will, the state is going to determine who inherits from you. And it really depends on state law. It depends on if you're married, depends on if you're married and you have kids from a prior marriage. So there's a lot of factors that go into determining who inherits from you. And it is state law specific, so it can be a little bit different depending on which state a person died in. So heirs are who would inherit without a will. Beneficiaries are who inherit through the will. When you die and you have a will in place, the heirs and the beneficiaries receive notice. That's important to note because sometimes you don't want your heirs to know everything, right? But your beneficiaries, it makes sense. Beneficiaries need notice because they're going to be inheriting, but heirs also receive notice. Okay. Then the personal representative has to determine the assets, what they are, and the value. We usually appraise everything. So real estate definitely gets an appraisal. That's for tax purposes, both the estate tax and also for income taxes on behalf of your beneficiaries. So we need to get an appraisal of the assets, and then we file an inventory with the court. So the court knows all the assets involved in the probate. We also give notice to creditors. Any known creditors will receive actual notice, meaning we will send them paperwork that says, hey, we think you might be a creditor. You have 30 days to make a claim. Otherwise, your claim is barred. We have to publish notice in the local newspaper to allow any creditors out there that are unknown, hard to find. We have to give published notice, and that way, any sort of unknown creditor has 4 months to make a claim against the estate. And it's actually a really good thing to do because then we can cut off any future claims. Let's just say a person died and we publish notice, 4 months run, 4 months is the time period. And then a creditor makes a claim against the estate. Well, it's too late. It's too late at that point because 4 months have already passed. So that's a good thing to do, but it's also, again, part of probate. It's what adds to how long it takes to go through. We have at least a 4-month period for creditors. The personal representative has to pay all of the last debts and expenses of the deceased person, including taxes. So that's part of the probate is they are going to determine who their creditors are, pay those creditors off. They're also going to file tax returns and pay those taxes. Then the personal representative also has to account to the court before the court will allow the probate to be closed and assets distributed to the beneficiaries under the will or heirs if there is no will. The court needs to be satisfied that everything has been done that needs to be done. So we have to prepare an accounting to the court, or the personal representative prepares an accounting to the court. And that's where the court is informed regarding, here are all the assets, the probate assets. This is what happened to them during the probate. For example, lots of times we are selling real property instead of dividing that property among 3 people. And this is the expenses we paid. These are all the creditors. These are all the creditors that were paid. And this is what's left over. And what's left over is what we want to disperse. So that accounting gets filed with the court for the court to be satisfied and be satisfied that everything's been completed as required. And then finally, the personal representative is asking the court to disperse the assets. So notice that no disbursements have been made yet. That's because it's simply not allowed. The court is the only authority that can tell the personal representative when assets can be dispersed. That is at the end of the probate process. So no disbursements are made. Essentially, the personal representative is the gatekeeper. They're keeping all the money, all the assets until they're ready to be dispersed. So they're keeping them not in their own name, but in the estate's name. And they're protecting those assets during this time period. So then once the court authorizes distribution, assets are dispersed. And then ultimately, once they're dispersed, the court wants to know that they're dispersed. So we're having beneficiaries and heirs sign receipts, filing those with the court. And then finally, we can close the probate down. So that is, there could be more to it depending on how complex the estate is, but that's the general process from appointment to distribution. So what's so bad about that? What's so bad about probate? Well, it's all a matter of your own personal opinion, but all I can tell you is that from what I have experienced with my clients, and also I have some personal experience with it, is that it's the time it takes to go through probate, and it's expensive. Those are the two big downsides to probate. The time it takes to go through probate is about a year. And if you have any sort of speed bumps that occur in the probate, it will take longer. And unfortunately, that's just what it is. You have some jurisdictions that will take even longer than that. Also, if, some counties, depending on which county the probate is going through, some counties might be a little longer than others as well. So it just depends on what's going on in the probate, even what's going on in the world. I can tell you with this COVID, the pandemic that occurred or is still going on, I guess, it really delayed these probates. We had very simple probates that were ready to close, and they were delayed an additional 6 months because of COVID. So it can take a long time. And anytime you delay, there's issues that come up that delays probate. It just costs more money. It just does. You can generally spend about 2% of the value of the probate assets on the probate process. So, if you have $1 million estate, 2% of that, what is that? That's, $20,000, I think, if I'm doing my math right. So yeah, it can be a very expensive process. The time also affects your dependents. If you have children or even a spouse that is dependent upon you, it would be very difficult, if all the assets are tied up, and they are tied up, the personal representative is the only one that has access to them, and they cannot be used except to pay administration costs of the estate. So if assets, let's just say someone died and they have an account, that account is a probate asset. That account is also what's used to pay the mortgage on the house. Until the personal representative has control or authority from the court, that mortgage isn't getting paid. I have that come up often where people say the mortgage is due, we're waiting to get appointed through the court, which, by the way, some counties are literally 3 months out just to get someone appointed. What do we do? And basically we say, if you can, still pay the mortgage, because we don't want to cause a problem with the mortgage company. Pay it out of your own pocket, and once you're appointed, we'll get reimbursed. It's never a good situation to be in, right? So if you have dependents who need money while the probate is going on, we have to actually ask and petition the probate court to get some money out of the probate to allow these dependents to you have access to or use some of the money. And that, just doing that in itself, takes some time and also causes more expense to the probate. So that's another kind of downside to the probate. The other is it's a matter of public record. And this may or may not be important to you, but it's important to know in making your decision as to whether you want to take some steps to avoid the probate process. So anything that you file with the probate court, including the will, including the inventory, including the final accounting, that's all a matter of public record. And that means that anyone can go and find out what your will says, what assets you had, who your creditors are. So a lot of people don't like that aspect of it. The other downside with the public piece is that if you do have any problem heirs out there, they can get access to all the information and possibly cause a problem within the court, such as contesting the will. Remember when I said that all the beneficiaries and heirs receive notice? If you have any problem heirs out there, they are going to get notice of the probate, and it gives them a forum to cause some problems. And it only takes one person. If there's any one person causing a problem, and it could be a very small problem, it could just be someone saying, "Hey, I want to know what's going on." It will delay the probate. Now, another is when it comes to real property, probates are required in the jurisdiction that the probate or the property is located. So having, representing both Oregon and Washington residents, lots of people have property in both states. They'll have, property on the Oregon coast, but they'll live in Tacoma. So a probate would be required in both Oregon and Washington if you own real estate in two different states. So that adds to the expense quite a bit. So those are some of the downsides of the probate. Now, many people, when they hear this, just when they hear how long it takes and that really we're under the court's control in terms of timing, they want to know how to avoid probate. There's lots of ways to avoid probate, and I am going to preface this as talk to your attorney because there are ways to avoid probate, but there could be some other factors to consider as to why you may not want to use this type of method to avoid probate. So definitely talk to your attorney before you make these sort of decisions. But one is joint ownership. If you own a bank account jointly with another person, the surviving joint owner becomes the sole owner of that account on the death of the deceased person. Usually, and what it requires is showing a death certificate to the bank, and they usually just take the deceased person's name off the account, and that's it. So that avoids probate. We do not look to the will with jointly owned accounts. Instead, it goes to the surviving joint owner. The other is naming beneficiaries on your accounts. And this happens a lot with retirement accounts, your IRA or 401ks. We almost always name a beneficiary, and I highly recommend that is the case. It's one of those, if you don't have one, I'm telling you right now, go do it. That is because that beneficiary will inherit that asset without going through the probate court. If there's a beneficiary on the account, essentially a death certificate is provided to the institution, the financial institution, and then the financial institution has the beneficiary fill out some paperwork, and then basically the asset gets dispersed to them in one way or another. You commonly hear this with transfer on death or pay on death, TOD or POD accounts. That's what it means, is that you have a pay on death beneficiary designated on that account. So beneficiaries, that's another way to avoid probate. Gifting, I wouldn't recommend you go and gift all your assets, but If you have probate assets and you can part with them, gifting them to your loved ones before you die is a way to avoid probate. Gifting is one of those things that I'd highly recommend before you do it. You talk to your legal counsel because there are some other tax implications with making some gifts. If you live in a community property state, and here I'm only going to specifically reference Washington because I'm licensed there and I know the Washington law could be different in other community property states, but at least in Washington, you can make a community property agreement with your spouse that says, my community property assets go to my spouse at death. And even if they are considered, that type of asset is considered a probate asset at death, by virtue of the community property agreement, no probate needs to be open to convey that type of asset to a surviving spouse. So community property assets. The other, and I think most common and my preference to avoiding probate, is creating a revocable trust. Now, a mini background on trusts, lots of different kinds of trusts. I'm talking about a revocable trust, which means the person who creates the trust can modify its terms during their lifetime while they have capacity. It's also called a living trust or an inter vivos trust. Unfortunately, there's lots of different names which mean the revocable trust. But a revocable trust created during your lifetime and funded can and will avoid probate as long as it's funded appropriately. I have my prior episode is actually all about the will and the trust, the revocable trust, and the differences between the two and what a revocable trust is. So highly recommend you go listen to that if you're curious about revocable trust. But I'll give you just a little mini educational update on those. The revocable trust basically is similar to a will. You create it during your lifetime. You decide who will inherit from you at death. Then you fund it, which means you take your assets and you title the ownership of those assets to the trust. For example, real estate, you have a deed, it's in your name. You would make a new deed, conveying it from you as an individual to you as trustee of your revocable trust. Or bank accounts. You have a bank account in your individual name. You'd go into the financial institution and say, I have a revocable trust. And you would rename that account so that your trust is the owner. That's called funding. When you create a revocable trust, your assets need to be owned by the trust. So that requires paperwork with, the financial institution or any maybe assignments of business interest in any businesses you have. And that is how we avoid probate. What's so great about a revocable trust is once you create it, it's similar to your will. You're designating who your beneficiaries are at death. But once it's created and funded at your death, your trustee is similar to an executor or personal representative. They are the ones tasked with administering the trust estate. Your successor trustee starts administering the estate the trust estate without having to go through the probate court. It's also really nice about a revocable trust is it's a private document. So privacy concerns, having your assets out there as a matter of public record, that doesn't happen with your trust. That's because we're not going through the court and reporting to the court. Only the beneficiaries under your trust receive notice that they are a beneficiary. So your heirs would not, just your beneficiaries. That's nice for problem beneficiaries, right? If you have dependents who need money or that you're supporting prior to your death, the trustee of your trust can continue helping and supporting them after you're gone, while they're administering the estate. Remember, in the probate, we have to go and ask the court for permission to disperse assets. That just adds to the probate cost and the time. And like I said before, it's like a 3-month turnaround right now for some of the courts to get anything approved. With a trust, we don't have that speed bump. The trustee can do those sorts of things. So that's really, really nice benefit of the trust. Also, if you have multiple properties in different states, we just title those properties under the trust, and we're not concerned at that point with a probate in 2 states. So trusts can be just a really great vehicle at avoiding probate and other reasons. And like I said, go ahead and listen to my first episode. You'll learn a lot more about the revocable trust. That does it for today's episode. I do have lots of resources on my website, and that is www.caresslaw.estate, and that is CARESSLAW.ESTATE. I also have a blog on probate questions and answers. We have the links in the show notes below. I look forward to seeing you next time. This is Tammi Caress. Thanks for listening.